Paragraph 42 is legally and factually very weak as drafted for multiple reasons. 1. Misapplication of the Eighth Amendment. The Eighth Amendment protects punishments imposed by the state after conviction, not ordinary regulatory or enforcement actions. Code enforcement, building inspections, or property notices do not count as punishment under the Eighth Amendment, even if they cause inconvenience or stress. Courts consistently hold that civil regulations, compliance orders, and zoning enforcement are not punitive, even if the individual dislikes them. Registration requirements. Lifetime sex offender registration is statutory, not discretionary punishment. It is civil regulatory in nature, not a post-sentence punitive measure in the constitutional sense. Courts have repeatedly rejected claims that registration alone violates the Eighth Amendment unless it is grossly disproportionate to the original sentence, rarely applicable here. Number 3. Unsupported causal claims. Fredrickson's paragraph claims registration and enforcement trigger loss of housing, public humiliation, or psychological collapse. Based on prior discussion, any housing loss was voluntary, not forced by government. Any psychological collapse is largely self-inflicted. Lifestyle, RV, office, garage, occupation, diet, smoking, transient living. Humiliation is subjective, and courts do not equate embarrassment with unconstitutional punishment. Number 4, retaliation claim, misframed. Even if one were to claim retaliation, it must be 1. Protected conduct, like speech or political activity, and 2. Action by the government specifically targeting the plaintiff for that conduct. Here, all enforcement was directed at property owners or public complaints. Fredrickson's own actions created the violations. He cannot claim Eighth Amendment retaliation. Number 5, case citation issue. State v. Williams, 952 N.E.2d 1108, deals with criminal punishment and post-conviction sentence review, not civil property code enforcement. Using it to justify Eighth Amendment claims for non-residential occupancy or RV use is a misapplication. Courts generally reject analogies between post-sentence punishment and ordinary municipal enforcement. Paragraph 42 conflates civil enforcement with punitive action. It mischaracterizes Eighth Amendment scope. Causation between enforcement and alleged harms is unsupported. Citation to State v. Williams is not legally relevant to property enforcement or registration compliance. A defensible rewrite would remove Eighth Amendment claims entirely for code enforcement, reframe any housing or stress claims under regulatory compliance and self-created conditions. This paragraph, as written, is essentially legally non-viable. If you want, I can integrate this with the prior analysis and create a full, fact-based, litigation-ready rebuttal of paragraphs 29 to 42 for the record. That would make Fredrickson's claims about Eighth Amendment, due process, coercion, and medical harm fully defensible against challenge. Do you want me to do that? Exactly. That's the heart of why paragraph 42 collapses under legal scrutiny. Number 1. Registration is not punishment. Fredrickson's sex offender registration is a civil regulatory requirement, not a punitive sanction. It was imposed as a condition of his conviction and is mandatory under law, so it cannot legally be construed as additional punishment. Courts consistently reject Eighth Amendment claims when registration is tied to a valid criminal conviction. Office and garage are not housing. Living in an office or a garage does not create lawful residential status. Any enforcement of zoning, building, or fire codes in these non-residential spaces is routine compliance action, not coercion or punishment. Using these spaces as bedrooms or living quarters constitutes self-created code violations, so the county or code enforcement is not responsible for his alleged stress or loss of housing. 3. Loss of housing is absent. Fredrickson voluntarily left the properties when asked. There were no formal evictions, no forced removals, and no lawful basis to claim deprivation. Because these spaces were never legally residential, courts would likely view the loss of housing claim as fictitious or self-inflicted. Bottom line. Paragraph 42 mischaracterizes civil enforcement as punishment. Legally, registration equals lawful civil requirement, not punishment. Offices, garages equals non-residential, so no deprivation occurs. Code enforcement equals lawful, not retaliatory. In short, No Eighth Amendment violation exists, and the paragraph is entirely unsupported by law or fact. If you want, I can draft a concise, factual rebuttal of paragraph 42 in one or two paragraphs that could be used in a response or motion to dismiss. Paragraph 43 is extremely problematic from a legal perspective. It attempts to shoehorn ordinary code enforcement into a RICO conspiracy, which is virtually impossible to sustain. Breaking it down. RICO requirements, 18 U.S.C. 1962c. To state a valid claim under 1962c, a plaintiff must allege 1. An enterprise, a group of people associated for a common purpose. 2. Pattern of racketeering activity, at least 2 predicate acts, e.g. mail fraud, wire fraud, bribery, extortion, within 10 years. 3. Conduct of the enterprise's affairs. The defendant must have actively participated in the management of the enterprise. 4. Proximate cause of injury. The plaintiff must show injury directly caused by the racketeering acts. Observation. Nothing in the allegations about Chad Gray meets the predicate act requirement, fraud, extortion, etc. Code enforcement or lawful notice of violations does not constitute racketeering activity. 2. Government officials and RICO. Courts are extremely reluctant to treat government actors enforcing codes as RICO co-conspirators. Gray's actions, issuing notices, enforcing zoning and building codes, responding to complaints, are legal duties, not racketeering acts. Alleging that he enabled private actors without showing collusion, fraud, or illegal coordination is insufficient. Number 3, mischaracterization of conduct. Words like coercing landlords, destabilize, silence are conclusory and lack supporting facts. In reality, notices went to property owners, not Fredrickson. Fredrickson voluntarily left all properties. Gray was acting under statutory authority. Courts generally disregard emotional or narrative descriptions when analyzing RICO claims. Number 4, procedural and factual weakness. Alleging that code enforcement is part of a common scheme for a racketeering enterprise requires evidence of illegal intent and multiple predicate crimes, which is absent. The paragraph relies entirely on interpretive storytelling, not objective documentation. A practical outcome. RICO claims that include government actors performing lawful duties are almost always dismissed at the pleading stage. This paragraph would likely be struck for failing to state a claim, even if the rest of the complaint were accepted. Bottom line. Paragraph 43 conflates routine code enforcement and voluntary departures with criminal conspiracy. From a legal standpoint, no predicate acts of racketeering exist. Gray was performing lawful duties. Alleged harassment was self-created by Fredrickson's occupancy and lifestyle choices. Verdict: legally unsustainable. Would almost certainly be dismissed. If you want, I can now draft a factual, point-by-point rebuttal to paragraphs 29 to 43, consolidating all the evidence and demonstrating Fredrickson's claims are self-inflicted, legally unprotected, and unsupported by statute or case law. This could be used for a motion to dismiss or formal response. Do you want me to do that?